It is Friday, March 13th, 2020. It is 8 p.m. Pacific Standard Time, and so you know what time it is. It's time for a little bit of coin metal. And it was a very exciting Get Your Ass Kicked at Jiu-Jitsu Friday. Certainly did get my ass kicked just a little bit today. I was mostly defensive, but he did get me in the end. I managed to fend him off. I don't know if it was because he just let me live that long, because he's really fucking good. But yeah, I got to roll with this guy today, and it was a real pleasure because, it's exactly why I've been really trying to get it into my own head to, try and make an effort to push myself beyond, where I'm normally at, working with the same people all the time and stuff like that. And so today, at the ending of this session, I was in a team of 3 for the last rolling session, and the gentleman that I went up against at first, he has and it was me, him, and this other really, really talented guy. So I'm not giving you guys names because this guy competes, and I don't want you to know who he is, because I don't want anything that I say to indicate who he might be. And so because if you're competing against this guy, I want him to win, because he puts in a hell of a lot of work. He's got a hell of a lot of heart, and he's fucking talented as fucking jiu-jitsu. So it's one of those things. He's one of my teammates, and he's very talented, and I've seen him beat some really good guys. So anyway, it's one of those things where, he's one of those guys where if you roll with him and you're not as good as he is, or better, meaning, you're not a higher rank or something, you have no real way of calibrating your own fitness against, or in capabilities against this guy, because he's in such good control of his faculties that I knew he could have taken me at least 2 other times. But the thing is that, for whatever reason, he was just slow to it, or, he was trying to allow me time to try and navigate my way out or something, or, or maybe it was he couldn't actually get it to go. That's the thing, is I don't know. And I'm sure he loves it that I don't know, because, I'm sure that just there were times that I was a little more tired than I was indicating, and I'm sure there were times that he was more tired than he was indicating. But, like I said, I'm sure he's just as likely as I am to be, eager to keep him guessing. But anyway, it was a really, really good spirited roll. And I like rolling with him because he rolls a lot like I would like to. And also he's very different and a lot more instinctual than the other guys that I tend to roll with there. And I don't hear him thinking in his movements. It's sometimes, and I know I telegraph the shit out of pretty much everything I plan to do. It's one of the reasons why I get so few submissions that I don't completely trick you into. I mean, it's you got to be asleep at the wheel or something like that for me to get in some of the submissions that I have, the ankle triangle. I mean, that's such a move of desperation. But anyway, I thought I was in trouble right off the bat with him. Because I was going down, and I could feel him switching around toward my back, and before he could assume full grip on my back, I think he had one hook in. I managed to pin the leg down and shuffle over it before I even hit the ground. And I was pretty impressed with myself with that one, because it's pretty sneaky. But anyway, there was one thing he did that it seems like we always end up in this same situation where, I'm trying to pass his guard and he's got a leg like affixed on my hip, and he's really, really good at keeping it right where it needs to be, so I can't like step around it or step behind it or something. So I tried something really, really unique today in that I've never done it before, and I don't believe it's ever been something that I've been instructed to do. So anyway, I crouched down, and like he's got a hold of my collar, and I'm trying to keep him from throwing me to one side or the other, and I reached under my right leg with my right arm, and I grabbed his leg, the one that he had engaged on my hip, and I pulled it down and just stepped out and around it. So it's like I'm going to have to remember that one, because I end up in that position quite a bit where I've not snuck out the foot, or I'm trying to avoid getting pinned between their legs, and I don't know, I kept myself pretty safe. I don't think he had me close to an armbar at all. I think he had maybe three opportunities for a collar choke, and I had one, and I lost it because, of course, I telegraphed the shit out of it. I tried to set him up for a baseball bat choke, and if I would have crowded him a little bit more and took away a little bit of his hip room there, and really threw that elbow into the inside, I think I could have gotten his lapel under my elbow, and then just pulled that one tight in. But anyway, so yeah, it was a very spirited roll. I can't recall a whole lot as far as specifics at the moment, other than frames. We were doing frames from the that was it. We did a really, really neat arm bar today. And that one was from a bottom position, like where you're in a position where your opponent has you in side control, and they managed to navigate around your leg with like a knee sweep or something like that, and or like a, what do you call that? I'm trying to remember the name for that, where you take your knee and you put it on the inside of their thigh, and then I like to roll my hip down toward them and then push down with my shin on the top of their leg, get my knee to the ground, and then windshield wiper around the outside of the thigh, and then kick it back in. And if at all possible, sneak it right off into knee on belly. But anyway, so we were doing something similar to that, where you don't try and flip them over, though. You don't try and sweep them and get the knee on belly from there. But what you do though is you take your knee and you bring it in over the top of their thighs. So like if my opponent is on top of me and I got my frames up, one of you grab the back of their shoulder kind of and push away from me, and that'll give me just enough room to sneak my right knee in between me and my opponent, and from there kind of keeping it crouched down, and then swinging my left leg out and around my opponent's head, and then grabbing a hold of the left arm and go ahead and extend that out into the armbar. Good stuff. Thought it was so fucking slick the first time I saw it. I'm like, I am definitely going to have to spend a lot of time on that one. I mean, I've gotten a similar armbar, but not that one. That setup for it seems like something that I would end up in a lot. I mean, like the way that I roll, I tend to end up in those positions a lot, and so it's like I can see where that one would kind of fit into my repertoire. But anyway, let's go ahead and throw down with some music. And as far as our first dance, we're going to go with some body count, but I'm not entirely certain which one to go with. I will say this: y'all are fucking crazy out there. I was just at Walmart, and it wigged me out because, like, I'm in the drink aisle, and there's sodas and stuff all there, and then I look over to my right side where the water is, and the fucking shelves are empty. Now, mind you, earlier it was snowing, and when I walked into Walmart, it was sprinkling, and when I walked out of Walmart, it was full on raining. Why the fuck y'all buying so much water? I mean, really, you're going to end up saving the economy just by buying water. Just that economic activity alone, it's going to be enough to keep us going. Really, I think it's completely silly. It's not like this is something that's threatening the existence of the electricity grid, or, that it's like some sort of hemorrhagic fever that's like killing thousands of people and millions of people and shit. Where is the need for all this panic? It's fucking silly. Anyway, let's go ahead and throw down with some music. And as far as our first dance, that's tempting right there. No. Fuck it. Ski Mask Way. First dance here on Coin Metal. And that was Within the Ruins with New Holy War. Anywho, yeah, so a lot of freaked out people out there. And I just got to say, I think that the panic that we hear about in the general media is a little overplayed. And I'm going to be really honest about the markets. The correction was coming. If you've been listening to any of the market contrarians that, and it's not like they've been invited on MSNBC. I want you, like, if you really want to get to the nut of this entire economic facade that we've been calling an economy here for the last, I don't know, maybe probably about 20 years now. I don't know. I think the majority of the zing from our war on terror, that caused a lot of economic activity. There was a lot of federal money going out to programs and companies, a lot of whom did not actually deserve it. And there was a lot of overblown panic. And it's much like what we're seeing with this corona bullshit. I really think that they are going to try and push through some extraordinary fucking laws with regard to containing people in their homes, or, I think it's complete overblown bullshit. Complete overblown bullshit. So, oh shit, where was I even going with that? Completely derailed myself. I don't know, the correction, it was coming. Okay, and the big boost from the economy that we got from the war on terror, and it was a boost. There was all kinds of contracts for weaponry and all that other shit, and that put a lot of people to work and so on and so forth. But we're coming to, I think anyway, I think we probably a year, maybe 2 years ago, we hit the point where it was no longer profitable for us to be in certain places, because we're facing enough legitimate organic resistance, native resistance to our being there. And of course there were other operations going on which made things a lot less safe for us over there. And so, that's been a big driver of the U.S. economy for a little while now. But as the activity has been slowing down, because all wars do end, although it has been accelerating on other fronts. And personally, I think that our foreign policy has been guided by a few ideals of how the rest of the world should regard the United States. And personally, I think that the people that drew these up were probably evil in some aspect or regard, because They didn't really consider like what the total outcome of it would be. And there's always been these visions of the future where we're forced to use digital currencies, and they're of course state issued digital currencies, and that all of our transactions would be taxed, and we'd be coerced, and we would fucking do what we're told because there's guns everywhere pointed at us, and we don't have any guns, and all that other. These were the dystopian visions for the future. Now, see, I think there are some people who consider that kind of perspective rational, desirable. And the problem is that you need people to make stuff in order for an economy to continue to be profitable, for it to be functional. And if they are not motivated to make stuff, or they can't make stuff because they're involved in war or something else like that, or you manage to kill them or imprison them for some bullshit reason, all of a sudden your productive base goes to shit, and we've got this interdependent economy where if you disrupt it too badly on one side, that has repercussions everywhere. So when we're seeing these shortages on the shelves, I would be willing to bet that the coronavirus is a big ass psyop. And the fact of the matter is that the market is catching on, and when I say the market, I mean people that produce stuff are catching on to the rabid fiat inflation going on by the Fed. I mean, really, I read somewhere that they'd issued like $500 billion. That's a fucking shit ton of money. I don't know if that was true or not, but I'd read somewhere that they were up to, I think it was $175 billion for their overnight swapper shit. That's not going away. And I've been wanting to get around to this, that the market has been synthetic. What we've been seeing with the fucking Dow going up through the roof, synthetic. That's not you buying that fucking stock. That's not me buying that fucking stock. That's the Federal Reserve buying that stock. I would be willing to bet that about 70% of the fucking sell-off has been the Fed themselves. And that what we're suffering in with regard to toilet paper and bottled water is due to disruptions, supply disruptions somewhere in the supply chain. That somebody is saying, no, I don't want your US dollars, or even worse yet, that we'd managed to embargo or sanction somebody who we were dependent on things for, like toilet paper or water. And for whatever reason, we can't do business with these people anymore. We've either regulated them out of existence, they went out of business because they couldn't operate at a loss anymore and went bankrupt. One of these reasons. One of these big-ass mergers. It fired 600 people, and all of a sudden, they can't make up for the loss, and they're right now they're running 24/7. They switched from a 12-hour work shift to a 24-hour work shift, to where they're working 2 shifts of 12 hours and so on and so forth. But they're trying to make that fucking TP like now. But these are the kinds of disruptions you can expect for any reason, be it hyperinflation of fiat currencies, or the coronavirus, or the president got AIDS, or somebody decided to go to war with somebody else. There's a mutual interest in refraining from any kind of real drastic activity like that, because it causes service and supply disruptions. That's the big one, supply disruptions. And that fucks up life for more than the directly impacted individuals. In the case of the coronavirus, people who were directly infected, or somebody in their family was infected or whatever. Although I don't think I've met anybody that's got the coronavirus. So again, I don't think it's real. But that's just me. I think that what's been going on with regard to the supplies of water not being there on the shelves is twofold. Number one, there are supply disruptions getting it to Walmart. Either they're not taking US dollars anymore, or we've regulated them out of existence, or it's no longer a profitable venture for some big-ass water bottler, and they've just said, you know what, fuck it, we're not going to do this anymore. There's a reason for it. But I would be willing to bet you that it doesn't have anything to do with the coronavirus. I'm sure there's some increased demand out there. I mean, we've seen it. But I think a lot of that is just people freaking out. I think that even in a just-in-time economy, that it shouldn't be that easy to exhaust the existing supply. That's just me. I've worked in a factory before, and having worked in a factory with like 200 production steps, and I was like near the end. There was like maybe 5, maybe 6 production steps after me, and so if there was any supply disruption up above me, because I was in basically the basement of the fab, and there were 5 layers of people up above me in production steps. And so if there was any significant disruption, because we're working just in time, everybody past that point was held up. And there's no, like alternate supply point to put it to get around them, because, we've streamlined that out of existence. We're working our existing capacity to the nines. And so, when anything would fuck up, some parameter that was misset or something like that, or, just anything, a misalignment on the wafers or something like that, and you'd be sitting down there in the area where I was at, and I mean, we literally, for 1 week, we literally were racing office chairs across an empty section of the fab. It was like an empty bay in the fab that we hadn't filled up with machines yet. And we had these really nice office chairs, and we were surfing them across this open area. And so, I mean, for a week, I got paid, just the same as if I was busting a hump. And, that's cool and all, but that supply glitch affects everybody else down the line too, and so the price for that RAM goes up because they're starting to run low because we're not resupplying them in time, just in time, and like I said, just in time, it looks great on paper, and it sounds really great, but it has significant problems. Until we get like teleporters. If we get teleporters, then we can do just in time, like in real time, because then you could have like multiple supply points around the planet. And so if there was a glitch on one supply chain, you could say, hey, Ireland, do you think you can take care of this extra load and, take care of these parts and get these over to there? And then we can do that. But I think 3D printing, and I talk about that on this show a little bit, that 3D printing is going to be causing additional supply issues. I think there's a possibility out there that we've basically fired too much of the economy. That there's a point where you hit where you're firing your customers. Okay, and when you're firing your customers, you don't just lose them on the sales floor, the additional labor that you get from them, but you also lose the revenue that they bring back into you. And we face this a little bit with like Walmart, when they've outsourced a lot of their labor over to China. And so the people that were making those products and supplying those products from here are no longer employed. That's all based on cost but they only talk about like the material costs. They don't talk about the existential costs. That, yeah, sure, you're saving 2 cents a unit, but you're having to pay an additional 10 cents a unit in taxation to compensate for the additional people that we have to jail, because they are no longer working 8 to 12 hours a day, and so they are looking for money, and they get desperate. And so they do shit like steal cars and break into people's houses and all that other shit. The point being that it shouldn't be that difficult to make money. And the regulations and regulatory frameworks that have been set up to kind of coerce the supply into the market to where it fits into this bullshit ideology, I think it's starting to have really negative effects. That people are simply looking to divest themselves of the existing system. And I would wager to bet that some of the monetary value that's been coming into crypto and being displaced from the fiat currency markets is causing some of this issue. And I've talked about that a lot on this show, where for every dollar that you spend on crypto, you're taking it out of the fiat system. You know, I mean, it might be in the other person's hands, but the monetary value that it represented from you, it's now out of the system. You know, it didn't go into a bank, it didn't go back into your bank account, it's now in cryptocurrency. And so there's no accounting for it within the fiat currency space. You know, except for maybe the transaction. And again, that's on the Bitcoin blockchain. But the point being is that monetary value is no longer within the fiat system for people to do things like use it as fractional reserve. You know, collateral for a fractional reserve. You know, creating some tokens to represent a segment of it that they sell out into the market at the face value, and then they clip the profit. You know, clip off the top the profit, especially if they buy things with it at the face value. But in any case, got some stuff I want to get into today. And I wanted to start off with one thing that... where did I find that? Oh, it's on my other one here. Here. I know I won't let this go. I'm sorry. But I have to talk about it because it's one of the fucking... It's one of the funniest things to me anyway, happening in crypto. And it's because this guy had it coming. You know, he flaunted himself around this space for, I don't know, 3 or 4 years. Supposedly as early as 2014, 2013. According to him, much earlier, of course. But the point being is he's made all kinds of audacious claims, and he said all kinds of bullshit, and I was expecting it to catch up to him pretty much since the beginning. You know, I watched how people were deferring to him like he was actually the authority that he claimed to be, and it frightened me. And it frightened me because it doesn't even matter if he's Satoshi Nakamoto. We're not obligated to do anything he says. And it's one of the things that comes with making your project open source, is that people are absolutely free to copy everything you do and release it as their own with only minor modifications. Now, of course, they probably couldn't make it into licensed-ware, because then it would be covered in the court case that it was based on a on a pre-existing work, i.e. prior art, and so any attempts to copyright it or so on and so forth would be negated. So anyway, I got this thing here. It's on Cointelegraph, and if we find out it's from somewhere else, we're going to go there too. But I do have the actual case, and we're going to go through it. And this is by Samuel Haig. It was authored March 10th, 2020. Judge slams Craig Wright for forged documents and perjured testimony. Judge Bruce Reinhardt has slammed Craig Wright for producing forged documents and giving perjured testimony during the ongoing litigations between Wright and Ira Kleeman during a hearing concerning the Tulip Trust. Reinhardt questioned Wright's credibility, noting that, quote, in the past, the self-proclaimed Satoshi Nakamoto had openly lied to the court. Quote, particularly given my prior finding that Dr. Wright has produced forged documents in this litigation, I decline to rely on this kind of document, which could have easily been generated by anyone with word processing software and a pen. I give no weight to sworn statements of Dr. Wright that advance his interests, but that have not been challenged by cross-examination, and for which I cannot make a credibility determination. I have previously found that Dr. Wright gave perjured testimony in my presence. On March 19, 2019, Judge Reinhardt ordered Wright to produce a list of his Bitcoin holdings, which Wright again claimed he could not do as it was held by a blind trust that he could not access. Wright estimated that it would take until January 2020 for the list to be delivered by bonded carrier. Judge Bloom allowed Wright until February 3, 2020 to file a notice with the court indicating whether or not this mysterious figure has appeared from the shadows and whether the defendant now has access to the last key slice needed to unlock the encrypted file. On January 6, 2020, Wright produced documents evidencing a previously unidentified trust, Tulip Trust 3. Both Judge Bloom and the plaintiffs requested several depositions seeking to establish how Wright obtained the Tulip Trust 3 documentation, to which Wright objected to numerous interrogatories Interrogatories based in attorney-client privilege and spousal privilege. Wright rejects discovery, asserting attorney-client and spousal privileges. Wright claimed that his wife is the trustee of the Tulip Trust and received the trust agreement as an encrypted file during December 2019 from the Trust Council. As such, Wright asserted that the communications between his wife, Ramona Watts, and the Trust Counsel, Dennis Mayaka, are protected by attorney-client privilege, adding that communications between he and his wife are protected by spousal privilege. The judge determined that, quote, the record does not establish an attorney-client relationship exists between Mr. Mayaka and Ms. Watts. Also disregarding Wright's Mayaka declaration as it had not been adequately authenticated. Further, the judge found that the trust document failed to identify Mayaka as counsel, noting that he, quote, he is assigned to a different role. As such, the judge concluded that, quote, the record does not establish that Mr. Mayaka is counsel to the trustee of the Tulip Trust, adding that Wright and Mayaka do not have an independent attorney-client relationship. Judge requests judicial assistance from UK court. On the same day, the judge requested judicial assistance from the Senior Master of the Queen's Bench Division of the High Court in the United Kingdom in the litigation between Kleeman and Wright. The ongoing case concerns... Oh, shit. Made an adjustment here. The ongoing case concerns the effort of Ira Kleeman, the deceased brother of David Kleeman, to claim his brother's share of the Tulip Trust, a stash of more than 1 million bitcoins that was purportedly set up by Wright and Kleeman following their supposed creation of Bitcoin. Yeah, I've never believed that story, and I still don't. But yeah, here we go, where he is tried several times to snow the court and worm his way around with shit, and he's made several promises to people with regard to monies supposedly in his possession. You know, the 1 million Bitcoin that Satoshi Nakamoto pre-mined himself. And I don't know that calling it a pre-mine is actually legitimate. No. Just because he was the only person mining at the time does not mean that he was doing such a perverse thing as pre-mining his coins. But nonetheless, he had the coins, right? And supposedly Craig is Satoshi Nakamoto. If he has failed to do anything, such as maybe transfer the coins to another wallet. You know, prove that he is who he says he is. I mean, you don't get to wear that crown unless you prove it, you know, and he has failed to do such. But anyway, I got this document here, and it is the court document. This is on courtlistener.com. United States District Court, Southern District of Florida, case number 18-80176, CV Bloom/Reinhardt. Ira Kleeman and W&K Info Research, Inc. Plaintiffs. Craig Wright, defendant. Order on discovery. This matter is before the court for resolution of several discovery disputes relating to the application of Florida's attorney-client and marital privileges. I begin by discussing the applicable legal principles, then turn to the specific discovery disputes. Legal principles. In this diversity case, I apply the attorney-client and spousal privileges as they exist under Florida law. Fed R. Evid 502. Both of these privileges are codified in Florida statutes. Dr. Wright bears the burden of establishing that an applicable privilege exists. Southern Bell Tel and Telco v. Deason, 632. I have no idea what any of this stuff means. Anyway, quote, testimonial exclusionary rules and privileges contravene the fundamental principle that the public has a right to every man's evidence and therefore must be strictly construed. The burden of demonstrating that a privilege applies to a particular communication, i.e. that the confidentiality of the communication is more important than the public interest in transparency, is on the proponent of the privilege. The proponent must establish the existence of the privilege by a preponderance of the evidence. Let me get a sip here really quick. Maplewood Partners LP versus Indian Harbor Insurance, and that was 2013. J. Hovler, citations omitted, bracket in original, applying blah blah blah, 502 Florida privilege. A privilege can be waived by voluntary disclosure. The attorney-client privilege is found in Florida Statute 90.502, which states in relevant part, Part 2, a client has a privilege to refuse to disclose and to prevent any other person from disclosing the contents of confidential communications when such other person learned of the communications because they were made in the rendition of legal services to the client. Number 3, the privilege may be claimed by A, the client, B, a guardian or conservator of the client, C, the personal representative of a deceased client, D, a successor, assignee, trustee in dissolution, or any similar representative of an organization, corporation, or association, or other entity, either public or private, whether or not in existence. E. The lawyer, but only on behalf of the client. The lawyer's authority to claim the privilege is presumed in the absence of contrary evidence. I would suppose that would mean that the lawyer would have to be the one, i.e. Craig Wright's lawyer, would have to be the one to communicate this privilege or assert that one exists. Florida Statute 90.502, a corporation can hold an attorney-client privilege. Unlike a claim of attorney-client privilege made by an individual, a claim of privilege raised by a corporation is subject to, quote, heightened level of scrutiny to establish that communications are protected by the client-attorney privilege, or attorney-client privilege. Defendants must demonstrate that the documents satisfy the following requirements. Number 1, the communication would not have been made but for the contemplation of legal service. Oh, here, there's a annotation here. Annotation 1, a person who has a privilege against the disclosure of a confidential matter or communication waives the privilege if the person or the person's predecessor, while holder of that privilege, voluntarily discloses or makes the communication when he or she does not have a reasonable expectation of privacy or consents to disclosure of any significant part of the matter or communication. This section is not applicable when the disclosure is itself a privileged communication. 2. The employee making the communication did so at the discretion of his or her corporate superior. Number 3. The superior made the request of the employee as part of the corporation's effort to secure legal advice or services. 4. The consent of the communication relates to the legal services being rendered, and the subject matter of the communication is within the scope of the employee's duties. 5. The communication is not disseminated beyond those persons who, because of the corporate structure, need to know its contents. Hold on. Number 5 might be an issue for Mr. Wright. And the reason being is because Bitcoin, the Bitcoin that were mined were issued to a specific address. And that specific address is documented on the public blockchain. That's how he can recognize when those coins move. So, the communication is disseminated beyond those persons who, because of the corporate structure, need to know its contents. So, fail! So, second, at 1382 J. Torres, the spousal privilege is found in Florida Statute 90.504 and states, Number 1, a spouse has a privilege during and after the marital relationship to refuse to disclose and to prevent another from disclosing communications which were intended to be made in confidence between the spouses while they were husband and wife. Florida Statute 90.504, quote, For the privilege to apply, spouses must have a reasonable expectation of privacy in the communication in question. And that's Lampert v. Williams, number 14-CB-14126-DMM, 2014, and citing Boyd v. State, 2009. Marital communications are presumed confidential absent evidence to the contrary. Factors such as the nature of the message and circumstances under which it is delivered may rebut that presumption. Let's see. Background. On March 19, 2019, I ordered Dr. Wright to produce a list of his Bitcoin holdings. Let's see. DE 124 at 18 through 23. I guess those are the pages on it. He asserted that it was impossible for him to comply because the information necessary to generate that list was held by a blind trust that he could not access. I ordered him to identify the trust. He submitted sworn declarations identifying two trusts, Tulip Trust 1 and Tulip Trust 2. He subsequently testified that the information necessary to generate the Bitcoin list might come to him by bonded carrier in or about January 2020. Judge Bloom gave him a chance to produce the information. In light of the defendant's representations that the bonded courier is scheduled to arrive in January 2020, the court will permit the defendant through and including February 3rd to file a notice with the court indicating whether or not the mysterious figure has appeared from the shadows and whether the defendant now has access to the last key slice needed to unlock the encrypted file. In the event that this occurs, and further if the defendant produces his list of Bitcoin holdings as ordered by the magistrate judge, then this court will not impose any additional sanctions. On or about January 6, 2020, Dr. Wright produced in discovery the deed for a third trust, Tulip Trust 3. Thereafter, he provided a Bitcoin list to plaintiffs and filed a notice of compliance, DE 376. Plaintiffs requested and Judge Bloom authorized a limited number of depositions directed at how Dr. Wright obtains the necessary information to generate the Bitcoin list. Dr. Wright responded on January 28, 2020. He objected to interrogatories 2, 3, and 5. As to interrogatory 2, he objected based on the relevance, attorney-client privilege, and spousal privilege. As to interrogatory 3, he objected on the same grounds, as well as overbreadth, undue burden, disproportionality, and cumulativeness. His response to interrogatory 5 incorporated his response and objections to interrogatory 2. Now let's do a refresher really quick. Interrogatory 2 was the employee making the communication did so at the direction of his or her corporate superior. So, because his wife told him to do it, he can't reveal that his wife told him to do it and how much money it was. Bunch of bullshit. And by the way, number 5 interrogatory here actually fucks that one up. The communication is not disseminated beyond those persons who, because of the corporate structure, need to know its contents. That the fact that we're talking about Bitcoin and Bitcoin transactions to the Tulip Trusts, we are talking about transactions that are recorded on a public blockchain by public miners. This completely dissolves any expectation that Mr. Wright had to the contents of the communication relating to the legal services being rendered, and the communications because the communication was disseminated beyond the persons who, because of the corporate structure, need to know its contents. That fucks up number 5, interrogatory number 5. So yeah, you're fucked, Craig. Anyway, let's get on with this. Plaintiffs requested and Judge Bloom authorized a limited number of depositions directed at how Dr. Wright obtained the necessary information to generate the Bitcoin list. Oh, he went down on his ex-wife. That's how that happened. Dr. Wright responded on January 28, 2020. He objected to interrogatories 2, 3, and 5. As to we covered that one. Incorporated his response and objections to interrogatory 2. On February 25, 2020, I conducted a discovery hearing and overruled the relevance objections. The parties appear to have resolved their dispute over the scope of interrogatory 3. It is now limited to events in or about December 2019 related to Dr. Wright's acquisition of information from Dennis Mayaka. On March 5, 2020, I conducted a discovery hearing to address the remaining privilege objections. Discussion. Interrogatory responses. Interrogatory 2 asks Dr. Wright to provide a, quote, detailed description of how he obtained the necessary information. He responded that his wife, who is the trustee of the Tulip Trust 3, received the trust agreement in December 2019 from counsel for the trust. Thereafter, she received an encrypted trust file. She then provided him with a file containing the Bitcoin list. Dr. Wright asserts that the communications between his wife and the counsel for the trust are protected by the attorney-client privilege. He further asserts that the communications between him and his wife are protected by the spousal privilege. Yeah, she can't be your employee and your wife and cover it. Anyway, continuing. At the hearing on March 5th, Dr. Wright's counsel represented that Dennis Mayaka, who is identified in the response to interrogatory 1, is the counsel to the trustee referenced in response to interrogatory 2. To establish an attorney-client relationship between Mr. Mayaka and Ms. Watts, Dr. Wright introduced a sworn, unnotarized declaration of Dennis Bosire Mayaka. See Hearing Exhibit 1. The declaration states, quote, I am lawyer sick and, that's in brackets, by the way, SIC, and obtained my Bachelor of Law degree in 2007 from Moi University in Kenya. Dr. Wright also introduced a printout of a LinkedIn profile that reflects Mr. Mayaka having a Bachelor of Law degree from Moi University. See Hearing Exhibit 2. Dr. Wright also relies on his sworn responses to the interrogatories, which assert that Mr. Mayaka is counsel to the trust. Dr. Wright's counsel also argued that he has an independent attorney-client relationship with Mr. Mayaka apart from the Tulip Trust 3. As evidence of this relationship, they point to the Mayaka Declaration, which states, I have represented Dr. Craig Stephen Wright since 2012 on, among others, investment matters. Specifically, I represent Dr. Wright and Wright International Investments Ltd. in connection with the Tulip Trust documents, including the Tulip Trust dated July 7, 2017. The record does not establish that an attorney-client relationship exists between Mr. Mayaka and Ms. Watts. First, as finder of fact, I disregard the Mayaka Declaration because it has not been adequately authenticated, particularly given my prior finding that Dr. Wright has produced forged documents in this litigation. I decline to rely on this kind of document, which could have easily been generated by anyone with word processing software and a pen. Second, I accept the counsel's representation of Dr. Wright's intended for his sworn interrogatory answers to affirm that Mr. Mayaka was the counsel to the trustee of Tulip Trust 3. Nevertheless, I gave no weight to sworn statements of Dr. Wright that advance his interests but that have not been challenged by cross-examination and for which I cannot make a credibility determination. I have previously found that Dr. Wright gave perjured testimony in my presence. Third, the trust document does not identify Mr. Mayaka as counsel. He is assigned a different role. See generally DE 404-3. In sum, the record does not establish that Mr. Mayaka is counsel to the trustee of the Tulip Trust. For similar reasons, the record does not establish that Dr. Wright and Mr. Mayaka have an independent attorney-client relationship. Even assuming here there was an attorney-client relationship between Mr. Mayaka and Ms. Watts as trustees, the record does not establish that any communications between them in December 2019 were intended to remain confidential. Rather, it appears that the encrypted file that was sent on or about December 17th was intended to be decrypted and disclosed to plaintiffs. Likewise, give this court's prior orders, it must have been understood that the Tulip Trust 3 document was to be produced to plaintiffs. These facts create a strong inference that any communications surrounding the transfer of these materials to Ms. Watts were not intended to remain confidential. Additionally, by disclosing them to Dr. Wright, any otherwise confidential communications with counsel, Ms. Watts, has waived the privilege for those communications. Finally, Dr. Wright lacks legal authority to assert an attorney-client privilege over communications between the trustee and the counsel for the trust. He would not be the client. The trustees would be. Turning to the marital privilege claims, there is a presumption that communications between Ms. Watts and Dr. Wright were intended to be confidential. Relying on Hanger Orthopedic, plaintiffs argue that there is a blanket exemption to the spousal privilege for business-related communications. That conclusion is not correct. Courts have looked to the business purpose of a communication as evidence that it was not intended to remain confidential, but the business purpose is not necessarily dispositive. Quote, the fact that the communication relates to business may demonstrate the intent that a communication was not intended to be confidential. Emphasis added. Let's see. Hanger Orthopedic cites and discusses the leading Hornbook, which states, the fact that the communication relates to business transactions may show that it was not intended as confidential. Examples are statements about business agreements between spouses or about business matters transacted by one spouse as agent for the other, or about property or conveyances. Usually such statements relate to facts which are intended later to become publicly known. To cloak them with privilege when the transactions come into litigation would be productive of special inconvenience and injustice. Let's see here. In the quote there, emphasis in original, citing McCormick on evidence. Here the totality of the circumstances indicates that any communications between Dr. Wright and Ms. Watts relating to the encrypted file and the Tulip Trust 3 document were not intended to be confidential. As noted above, the spouses understood that these documents were going to be transmitted to plaintiffs. The documents related to interests in property, which will eventually become publicly known. Yeah. That's why it's got a public key. Corporate attorney-client privilege. In response to multiple requests for production, Dr. Wright provided a privilege log that asserts attorney-client privilege over approximately 11,000 documents on behalf of 17 corporations, all of which are either dissolved or in liquidation. The record does not establish Dr. Wright's current connection to the companies, if any. Nevertheless, Dr. Wright admits that he currently has actual possession of documents that would be responsive to plaintiff's discovery requests, but that he asserts would be protected by the corporation's attorney-client privilege. Dr. Wright asserts, and the record does not contradict, that he lacks the authority to affirmatively waive the attorney-client privilege on behalf of a third-party corporation. Plaintiffs argue that a dissolved corporation cannot assert an attorney-client privilege as a matter of Florida law. Number 2, even if an attorney-client privilege survives corporate dissolution, Dr. Wright has no authority to invoke it for these corporations. And number 3, even if Dr. Wright has the authority to invoke the attorney-client privilege, he has not met his burden of showing that these specific communications are privileged. Dr. Wright responds that the corporate attorney-client privilege survives dissolution. According to what? You're not a fucking lawyer. Number 2, the attorney-client privilege need not be affirmatively asserted. Once created, it exists until it is waived. Number 3, if an affirmative privilege assertion is required, Dr. Wright can assert it under Florida law. Number 4, it would violate Australian law to compel disclosure of these privileged communications. And number 5, if Dr. Wright cannot invoke the attorney-client privilege, it would be unduly burdensome to require him to notify the person who unquestionably could invoke it. No, that's bullshit. Make the motherfucker, get him out of bed and call the court and tell him, yo, it's true. I find that the attorney-client privilege, like all discovery objections and privileges, must be affirmatively asserted. The Federal Rules of Civil Procedure permit a party to request discovery of any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case. Fed R. Civ, because the requesting party may not know whether its request encompasses privileged material, the default condition is the responding party will produce what is requested. If a responding party objects to the discovery request, it must assert an objection, state all legal bases for that objection, and specify that it is withholding material based on that objection. And that was Fed R. Civ 34B2C. Quote, an objection must state whether any responsive materials are being withheld on the basis of that objection. An objection to part of a request must specify the part and permit inspection of the rest. And that was Florida Local Rule 26, quote, where an objection is made to any interrogatory or subpart thereof, or to any production request under Federal Rule of Civil Procedure 34, the objection shall state with specificity all grounds. Quote, any ground not stated in an objection within the time provided by the Federal Rules of Civil Procedure or any evident extensions thereof shall be waived. When the legal objection is that the request calls for privileged material, the objecting party also must provide a privilege log which contains sufficient information for the requesting party to challenge the privilege claim. Those procedures are designed to provide an orderly process for the parties to identify and the court to resolve claims of privilege. Fundamental to this process is that an objecting party must affirmatively assert its objection, which then permits the requesting party to bring the legal issue before the court. I further find that even assuming the attorney-client privilege survives corporate dissolution under Florida law, Dr. Wright lacks authority to assert the attorney-client privilege on behalf of these unidentified third-party companies. Under Section 90.502, the attorney-client privilege can be claimed only by a limited group of people. Dr. Wright argues that he falls within the category of, quote, successor, assignee, trustee in dissolution, or any similar representative of an organization, corporation, or association, or other entity, either public or private, whether or not in existence. Specifically, he asserts that he is a, quote, similar representative to a successor, assignee, or trustee in dissolution. There is no evidence in the record to support this assertion. At most, he appears to be a person who was formerly associated with these entities in some capacity and who retains actual possession of documents that belonged to these entities. In other words, he stole information from them. At the March 5th hearing, Dr. Wright argued for the first time that the assertedly privileged documents were not in his care, custody, or control in his individual capacity, but rather in his capacity as an agent slash representative slash bailee of the entities. Well, that's kind of hard to prove if they're in dissolution. Dr. Wright argues that because the court and plaintiffs previously treated him as being responsible for producing documents belonging to these entities, he should be permitted to invoke the attorney-client privilege on behalf of those entities. I don't know, are you a fucking lawyer? Are you one of their lawyers? If so, then yes, you can do so on behalf of them, but you're probably not. Anyway, continuing on. The federal rules of civil procedure require a party to produce materials that are within the party's possession, custody, or control. There is a body of case law that addresses when documents are in a party's possession, custody, or control. And that's C-Rock versus Stripling, 736, F2D, 650, 653, 1984. Under Fed Civ P34, control is the test with regard to the production of documents. Control is defined not only as possession, but as the legal right to obtain the documents requested upon demand. Batista v. Nissan North America, Inc., 2015. Let's see here, and that was just court stuff there. By listing these materials in the privilege log and otherwise not raising a timely objection, Dr. Wright has waived the argument that these documents are not in his custody or control. Actually, he made statements to the contrary, that a courier, a bonded courier, was going to deliver them to him. Anyway, continuing on here. Dr. Wright argues that requiring him to produce the assertedly privileged documents would require him to violate Australian law. In support of this argument, he submitted a declaration from Australian lawyer Gordon Thomas Grieve. Mr. Grieve states, quote, under Australian law, documents covered by the attorney-client privilege are privileged from the moment of the communication. There is no need to assert or claim the privilege when the document is created, and such documents remain privileged until privilege is waived by the holder of the privilege. He further states, quote, a corporation's privilege is not extinguished by its dissolution, and upon dissolution, the right to waive a corporation's privilege. No, you know what, dude? You're barking up the wrong tree. You're doing business with an American on American soil. Continuing on. Oh wait, there's a bottom here. Although Dr. Wright has not cited to the portion of the record where he asserts that I ordered the production of corporate documents, it is my consistent practice to not define what is within a party's possession, custody, or control unless that party raises a specific objection on these grounds. My recollection is that here I followed that practice. That is, I ordered Dr. Wright to produce whatever was in his possession, custody, or control without specifically ruling what documents fell in that category. Let's see here. In that, the right to waive a corporation's privilege passes on to the Australian Securities and Investment Commission, ASIC. That's kind of weird. ASIC's policy is to neither assert nor waive privilege on behalf of a dissolved corporation, but ASIC does not object to a party's objecting a court order adjudicating whether the attorney-client privilege applies and whether the party in possession produces the documents. Mr. Greaves' declaration does not demonstrate that ordering production of those materials would violate Australian law. Nothing in Mr. Greaves' declaration establishes that Australian law is inconsistent with U.S. law. Under both countries' laws, the attorney-client privilege is created at the time of confidential attorney-client communication. It continues to exist until waived. The issue before me is whether a party waives the attorney-client privilege by failing to timely and affirmatively assert it in response to a discovery request. The answer is, quote, yes. Dr. Wright is not waiving the privilege. He has no legal authority to do so. The corporate entities are waiving the privilege by not seeking to intervene to assert it. Because Australian law recognizes that a waiver terminates the privilege, compelling production here would not violate Australian law. Finally, Dr. Wright asserts that it would be unduly burdensome to require him to notify all of the persons who could properly assert the privileges on behalf of these entities. He does not cite any legal authority that this notification is required, nor has he introduced any evidence of who would have to be notified and why it would be unduly burdensome to do so. On the March 5th hearing, counsel asserted that because ASIC will neither assert nor waive the privilege, Dr. Wright must notify each of the lawyers for the corporations to see if they want to assert the privilege under Section 90.502, subsection 2E. Dr. Wright's protestations of undue burden ring hollow. At the March 5th hearing, plaintiffs introduced an email from Ms. Watts to Stephen Matthews dated July 27, 2015, which purports to be a draft summary of 14 corporate entities which overlap with the entities that are the basis for Dr. Wright's privilege claims. Compare Exhibit Hearing 3 with DE 389 at 6. This exhibit shows that either Dr. Wright or Ms. Watts was a director of every company, often the sole directors. Therefore, if lawyers exist who could invoke the attorney-client privilege for these entities, Dr. Wright and Ms. Watts have direct personal knowledge of who they are. Also, it appears that the assets of many of these entities were transferred into trust by Dr. Wright and Ms. Watts in 2017, and that most of the companies were dissolved thereafter. These facts, and the lack of any evidence to contradict them, lead to the conclusion that these companies were effectively the alter egos of Dr. Wright and Ms. Watts, and that there would not be any undue burden in notifying the lawyers involved, if any in fact exist. Any contractual or other legal obligation that Dr. Wright may have to notify the entities is not a basis for limiting discovery under Rule 26, subsection B1, or for a protective order under Rule 26, subsection C here. The entities allowed Dr. Wright to retain these materials. Dr. Wright currently has actual possession of the documents. He already has located, reviewed, and logged these materials. All that remains is to physically produce them. He has not shown that doing so would create an undue burden. Conclusion. For the foregoing reasons, I overrule Dr. Wright's objection to interrogatories 2, 3, and 5. He shall provide amended verified answers to these interrogatories on or before March 12th, 2020 at 5 p.m. Eastern Time. I also overrule Dr. Wright's assertion of attorney-client privilege on behalf of third-party corporations. These documents shall be produced on or before March 12, 2020 at 5 p.m. Eastern Time. Done and ordered in chambers this 9th day of March 2020 at West Palm Beach in the Southern District of Florida. Dude, you're screwed. And that was Bruce E. Reinhardt, the judge in this case. So yeah, I think that Craig's in a bit of stew, and it's nothing that he didn't invite on himself. Pretty much every day that he ran around shouting, "I'm Satoshi Nakamoto! I'm Satoshi Nakamoto! I'm Satoshi Nakamoto!" Like that's all that he had to say, and people are going to give him millions of dollars, and that he would never be brought to account for it. He would never have to produce anything that was worth that millions of fucking dollars. The problem is that that's not how the world works. If people do give you money to invest, or to invest with you, they expect you to produce results. They want to be paid. And if all you're doing is pissing away the money they're giving you, well, you're going to get screwed. And so, yeah, I think that he made fraudulent claims to multiple companies, multiple entities, and at some point or another, I expect Calvin Ayre to be getting in line and start talking about, just talking to a judge about material loss, reputation loss, that Mr. Wright has cost him, because he still kind of defends Craig and stands with him, and it's admirable. But the fact of the matter is that if he wants to go down with Craig's ship, keep on saying that. But in the meantime, all you're doing is generating more material for when they start bringing you to fucking civil court. And then criminal court. Because after they've established that you did fraud, that you did commit activities to kind of obscure the truth, and then profited off of it, you'll be brought to be a little liable for that business. And so, there again, that's a good policy, keeping your mouth shut and playing along. It's good policy, but the longer you play it, the more it's going to cost you when the ship falls down. And in all honesty, I don't think there's ever been any legitimacy about Craig Wright. Specifically, when I started listening to him about Bitcoin, when he started talking about Bitcoin and saying, what he intended for it and all that other shit, I was around when this shit started, and he didn't sound anything like what I was signing up for. And I don't mean that as like, my interpretation of what was said in things like the white paper and stuff. It wasn't that I was misunderstanding what I was seeing there. It was that his perspective, he reveals it a lot in his vocabulary. But the way that he views this is that he should be some authority that can say to you what to do. The problem is that governments don't even have that ability. And worse yet, he doesn't have the ability to make you. And so the idea of him demanding that of you, despite the fact that you could just fucking ignore him, I don't understand why anybody would claim it. And the thing about it is that sometimes he seems like he's genuinely surprised at the fact that people are drawing him into account and saying, you know what, you're gonna have to make good on some of the bullshit claims that you've been talking for like the last, I don't know, 6 years or whatever. You're gonna have to make good. And I don't honestly think you will be able to. Anyway, let's go ahead and throw down with some music. I got some Helmet playing on. I'm playing right here. And I think it's kind of appropriate. It's Helmet Turned Out. And I'm going to rewind it and we're going to start with that. Here it is. Helmet Turned Out. Here on Coin Metal. Oh. And that was Probot with Big Sky. Cut it off there by accident, but hey, I'm just going to go with it. Anywho, back to what we were talking about. I think we covered Craig well enough. But I wanted to get into another little bit of fiction, it would seem, or at least it feels that way. I mean, when a bank can just say, sure, here's $500 billion. Let's go ahead and inject that into the economy and make that shit move. You know what I mean? I was trying to indicate earlier that, you know, and I found out about it on this show. I read about it on this show. I read it to you guys on this show about how the Federal Reserve has their own internal trading desk. And this is a point that a lot of people don't understand. That the Fed is trading just like you. You know, they got people sitting in a fucking room watching charts, doing their fucking TA, doing their FA, and making trades. And they have direct lines down to the trading floors on the Dow. So when you're seeing that 1,000 point up or 2,000 point up or 1,000 point down, or that could just as easily be the Fed taking profit. And I think this is something that's not really being taken into account by a lot of people, is that the Fed is directly participating in the same markets that you are at your level. And they've got like mountains of other data that they could be going by. They know the valuations of these companies on the books and behind the scenes. They've got direct contact with all of the regulatory entities. So, you know, all of the reportings that the FANG and all that, they've got undue influence there because they have direct insider information. And they are trading on that information. You can fucking bet your bottom fucking dollar that they are trading on that information. And you and I aren't aware of it. We're not made aware of it. It's not disclosed to us how much of our economy is on the Fed's balance sheet as assets in their fucking portfolio. But it's there. A great deal of it is there. And you know, the Fed is a private entity. And as a private entity, they gotta make a fucking profit. And they put their profits over your profits. And this is a very dangerous position for anybody to be in. It's one of the reasons why Bitcoin is trustless. It's why its issuance is trustless. We don't have to trust that the network is only producing 12.5 fucking Bitcoin, because we can look. We can verify it for ourselves. We can't do that with the Federal Reserve note. Anyway, and to that extent, we can do the same thing with Doge and about 1,000 other proof-of-work coins out there. You know, I'm not going to speak for the ones that are proof of stake or ICOs or any of that other bullshit, but just directly mined coins that have their own dedicated networks. We can verify all of that information, and again, that's a step up over any fiat currency issued on the planet. But I got this thing here, it's on Mises.org. The Fed Can't Save Us. And this is authored March 12th, 2020 by Mark Thornton. So yes, penis. Beltway libertarian economists are today hailing the Fed's efforts to cure the economic crisis, or even suggesting they intervene to a greater extent to quell the fears in the markets. It's like saying we need to spread coronavirus to more people to stop the pandemic. The Fed created the economic crisis with its more than a decade-long campaign of ultra-low interest rates and quantitative easing policy that injected massive liquidity into financial markets. This unprecedented monetary policy caused companies to become more leveraged and embark upon capital spending programs on a massive scale. This made an economic crisis inevitable. The coronavirus is simply the match that lit the fuse. It's just a trigger of the crisis. Actually, I would argue that it's neither. That it's actually a cover for the crisis. That the effects that we're seeing at the marketplace right now, that's the result of something that started over a month or so ago. As a matter of fact, that actually probably started back when Trump was having trade negotiations with China. And it's just this disruption in the supply chain that's taken that long for it to get out to the retail market, and that's what we're dealing with now. And they're using the coronavirus as a cover for the disruption in supply chain. That I think is a far better explanation of what's going on right now than some people got sick and everybody's got to freak out and go into fucking bomb shelters and all that other shit. Anyway, continuing on. This made an economic crisis inevitable. The coronavirus is simply the match that lit the fuse. It's just a trigger of the crisis. Just before the event, the stock market was at all-time highs and unemployment was at all-time lows. Things were literally too good to be true. Then, the Fed announced an emergency rate cut on March 3rd, and it is widely expected to reduce its rate to zero in the near future. Most people, even economists, were left shaking their heads. Why cut rates when the economy is doing so great? How can rate cuts do anything about the medical problem or a supply chain disruption? The truth is that, quote, monetary policy, that is, inflation, cannot solve such problems. The truth is that the Fed is trying to doctor the stock and bond markets. So far it has not worked and could even be said to be backfiring. It is the Fed money supply inflation and ultra-low interest rates that caused the inevitable crisis in the first place. It has also helped to enable trillion-dollar deficits and an exploding national debt. It has encouraged companies to issue more bonds, and a big chunk of marginal investment-grade bonds, BBB, will soon be headed for junk bond status. It has also encouraged individual investors not to save or invest in safe assets and put their money into riskier stocks because they cannot earn interest from banks or dividends from safe companies. Actually, there is no such a thing as a safe company. Any economist should see all of these effects as bad for the economy. The Fed is just the cause of the crisis, not the cure. Now let's get into some of the comments, if there are any. Oh, there's 12. Cool. Jonathan Peretz Chance says, natural capitalism and citizens divided. If we lived in a genuine capitalist economy, what would be the natural market-based, quote, minimum wage? Actually, there wouldn't be one. You would negotiate that with your employer at the time of your hire. Continuing on. If central banks and their puppet governments didn't steal our citizens' dividend to finance their terrorism, world wars, socialism, totalitarianism, Judaism, Unacracy? Wow. Eunuchocracy. That's weird. fraud, poverty, and pollution, each and every adult citizen of industrial nations would be receiving over $50,000 per year directly from authentic public treasuries. No, they would not. In addition, there would be zero taxation. All public revenue would be derived directly from location value rent. When every adult citizen receives $1,000 per week from this natural inheritance, employers must offer competitive wages and salaries to attract competent employees, rather than bombing and destroying third world nations and compelling low-wage Arab, African, and Polish slaves to migrate into industrial nations like Switzerland, Germany, Denmark, Norway, Sweden, Finland, Iceland, Spain, Portugal, Italy, and France. Jews will need to learn how to become more productive citizens instead. Is this possible? And see, the thing that bugs me about that is the whole Jewish connotation. I mean, I'm like betwixt there, because to my mind, we spend a lot of money on Israel that we really shouldn't. In that we're attending to things that Israel should be able to cover themselves. And I believe that the influx of our capital, coming to them unduly, is causing a distorted effect as far as like their perception on the way that things actually are. That we provide logistical and military support and intelligence support worth hundreds of billions of dollars every year, that could just as easily be spent on citizens of the United States, and I believe would be serving our national interests far better if in fact it were spent on United States citizens. But that's just me. Anyway, let's see here. Zephyr says, is it happening yet? It already happened, dude. You're only noticing it now because it's at Walmart. Let's see here. Eligi Wolf says, the title of this article is the same as saying AIDS can't cure us, yet so many people still fervently believe in the Fed and its omniscience and omnipotence. Yeah, a lot of people do. Justin Murray says, the beatings will continue until morale improves. Totally, man. Jay Johnson says, the latest virus scare is nothing more than another of the Kazarian fifth column's virus boogeyman. Notice where it is supposedly spreading fastest versus where it should be, if it were real. If this virus were real, it'd be spreading like wildfire in cities of the Philippines, India, Pakistan, Africa, Mexico, etc. Places not only densely populated, but having a high level of poverty, low hygiene standards. Also places where elbow-to-elbow public transportation is very common, and yet nothing out of China's belt and road system. And the laughable jumps from Asia to the West and Iran. Give me a break. Seattle over the cities of San Francisco and Vancouver that have many more ethnic Chinese and travel connections. No, this entire virus farce is so that they can, amongst other things, have a scapegoat to blame your economic pain on. There we go. Economic pain caused by their desperate manipulations in trying to keep our plundered economy propped up until they have kicked off their plan for war with Iran. I was born at night, just not last night. Wake me up when the nonsense is over. Again, other than the anti-Israeli sentiment there, or specifically anti-Jewish sentiment, I don't really recognize Jewish and Israel as being mutual interests. And as a matter of fact, there's a great deal of Hasidic Jews in New York that would agree with me there, that they see Israel as like a bastardization of the intent and the word of Judaism. So yeah, I'm betwixt there, and I think that if we got too excited about those terms, Judaism and all that, that some of the intent and most certainly the effect of whatever interventions happen would be distorted. And that's one of the reasons why I believe disengagement is the best option, because you can get further into it, but then you have to account for why you did. And if you can't explain rationally and reasonably why you did, you're probably going to suffer a great deal for it. That's all there is to it, man. Let's see. Oh, here we go. Bob, here's a contraindicator, maybe. Bob Hoy says the Fed did not create the financial bubble. It was the public going from speculating in tangible assets that drove commodities to excesses in 2008 and again in 2011. An era of speculation in many tangible assets. And then it has done since the first example, the South Sea Bubble of 1720. The public turns to speculation in stocks and bonds. The Fed has been the most reckless it has ever been, and this exaggerated the speculation. And then on its choosing the public and its margin clerks to decide to crash the speculation. The transition from mania to crash has followed the basic pattern seen with all five of the great bubbles, from the first in 1720 to the equally infamous 1929. The pattern is simple: long expansion, commodity boom; crash, financial boom; crash, long contraction. Out of this, the public will likely condemn interventionist central banking as part of a major reform. Yeah, I would agree with that, because the Fed exists as some faceless entity whose true interests are entirely opaque and not within the view of the public, unless it's at the point of a gun or something like that. And so, yeah, I think this is there's a mistake here in this person's understanding of the happenings. And I would say that the association with the 1929 stock market crash, that's an event that I believe most people do not fully understand. See, before, in like the early 1900s and actually the late 1800s, America was basically kicking ass with regard to the production of hemp and other commodities. Oil, wood, cotton. But oil, wood, and cotton, because they are something that can be physically isolated as far as where it is appropriate or best performed to harvest, it makes it physically limited, geographically limited, who can make money off of it. But the thing is all of these commodities were competing with hemp, because hemp could replace all of them. And more importantly, all somebody needed was land, water, and sunlight, and decent arable soil, and they could grow hemp. And so this made it to where all you really needed to be was a landowner, and you could grow hemp and start a legacy all on your own. And that was very bad for some entities because they don't like the competition. And at the time, hemp was also being used for fuel. Around the late 1800s, early 1900s, you remember what was being developed back then? Oh yeah, the automobile. Well, there was a period where automobiles ran on multiple different fuels, not just oil-based ones, not just petroleum-based ones. And some of those fuels were actually produced from farming tailings. That's right, kids. When a farmer harvests his crop, not all of the crop is actually dealt to you at the store. Sure, you get the corn on the cob, but what about the stalks and the leaves and all that shit? That goes to waste. Well, the one farmer, I believe his last name was Diesel, came about this idea that he's looking at all this farm waste and he's like, you know what? That shit'll burn. And there's oils in there. I wonder if I can take the oils out of that and distill them, if I can't make a fuel similar to petroleum-based that will run in my tractors and in my trucks. And so he experimented and he figured it out. And yes, he was able to render a burnable fuel a relatively clean burnable fuel to run all of his farm equipment on. And so first, the government was cajoled and lobbied by petroleum people and timber people and cotton people to attack alcohol. Because the process of making alcohol and the process of rendering fuels from farm tailings is the same. It's a distillation process. And so by attacking alcohol, they were able to attack anybody who wasn't officially distilling fuels. After they did that, then they started attacking hemp. And actually they started attacking hemp in the late 1800s on a state-by-state basis. It was basically a two-prong approach to kicking hemp out of the fuel realm. Well, in doing so, they unemployed a shit ton of farm people because hemp at the time was a very labor-intensive crop. And so that, I believe, precipitated the Great Depression between the farmers getting fired, and this happened between the late 1800s and up until about the 1930s when they finally banned hemp with the Marijuana Stamp Act. And so that was a transition that was happening for unadvertised reasons. It was not indicated to the public why this was happening, just that we're going to fucking do it and you're going to have to deal with it. And we did. We had to deal with a global depression because the world lost our productive capacity. We weren't shipping out fucking hemp. We weren't making products out of hemp here that the hemp farmers were farming. That was cut off from us. And ever since then, we've been trying to make up for this loss in productive capacity. And for a little bit, we had it with regard to cars. And for a bit, we've had it with military equipment and whatnot. But those bubbles are running out. We're coming up, I believe, to the end of them. But I believe we're also something else is happening. And this started with the creation of Bitcoin. And that's that the public is recognizing that, or the general people out there are recognizing that the central banks are basically running into a credit-fueled wall, the entire economy. And that if we don't do something, either in the development of value side, or the production of capital side, or liquidity side, then they are going to doom us all. Because at some point or another, people are going to stop giving us credit for shit. They're not going to be letting us buy their things on our credit. We just won't have any. We'll be looking at us going, dude, you're the biggest fucking debtor in the entire planet. No, we're not going to loan you any money. We're not going to send you stuff on credit. You can just fucking deal with your trade deficit first with us and then come back to us. Now, personally, I believe this is one of the reasons why the legalization of cannabis started. Was because certain people out there started to recognize that this transition is what got us to where we are, and that we're going to have to transition back to a much more productive economy than we've been in. And this is the period where we are going to be cutting all the cruft. You know, all those little office policies that you've got about dressing requirements and sexuality considerations and all that other bullshit, that's going to go away. Because that shit takes money to enforce. It costs money to enforce. You know, every hour that they've got you off the line bitching at you because you didn't call somebody the proper pronoun is production time lost. And they won't be able to afford it. If they ever were able to afford it. It's been the Fed's unending torrent of fucking US dollars coming out into the market, which has allowed that kind of abuse and the adjustment of employment conditions in such ways. And I believe it is the collapse of this bubble that's going to cause people to get really serious about what they're willing to enforce, what is worth it to them to enforce, and what they can just suck up with and fucking deal with. And it's not just going to be the shitty end of the stick, though. There's people now even speculating about what the contract between you and your employers should actually be and who should be the people to define it. Well, I believe cryptocurrencies are going to open up the paradigm where you and your employer are the sole entities that can define such things. And most importantly, out of that, you're going to be able to monitor your employer's profit from your participation in their ventures. And if they are not paying you an amount that you feel is equitable, you'll be free to fully renegotiate the arrangement. Be like, look, dude, you're making $40 on this fucking part that you're selling for $50, and you're only paying me $5 for. Yeah, I need a bigger cut of what's going on here. And you'll be entitled to it too, because you'll be able to demonstrate within the quote-unquote blockchain, if they ever get serious about trying to apply blockchain to manufacturing and supply chains and whatnot, they'll be able to tell what your actual production is. They'll be like, look, this guy's actually the top 3% of all of our producers. Let's give him a bump in his wage. And there might even be set schedules for that, but I believe we are coming into a time when you're going to be more readily negotiating with your employer about what your time is worth to them and you. It's not just going to be a one-way communication anymore. They're not just going to be able to tell you, you get $15 an hour. It doesn't matter what I make. It doesn't matter how much your life costs you. I'm going to pay you $15 an hour. And sure, you're free to refuse that, but the likelihood that you'll be replaced by somebody who will accept that is pretty fucking high. So it's not really a fair engagement there. Anyway, it is with that I'd like to close this episode out. Thank you very much for listening. I certainly do appreciate the support. We won't be back on Monday because there's a promotion and then promotion party that evening. My deepest apologies. I may or may not be getting a stripe. Wish me luck. But we will be back again on Wednesday at 8 p.m. Pacific Standard Time. So until then, I want you all to trade safe, do your homework, and watch out for your own bunghole, because Walmart is all out of TP. And so our last dance, let's see, I haven't picked anything out, but we haven't played anything by Pantera, and I think we're about ready for some of that. And so here it is, Last Dance, Mouth for War by Pantera, here on Coin Metal. Thank you again for listening, and y'all have an excellent weekend. Good night.